Welcome back to Pace Immigration, paceimmigration.com, talking with immigration lawyer Anna Aazam. Anna, good to see you.
Hi, Sean.
Talking today about humanitarian and compassionate grounds. I've got a definition here from the government website, Immigration Canada. We've got immigration through humanitarian compassionate grounds is for people who would not normally be eligible to become permanent residents of Canada and may be able to apply on humanitarian and compassionate grounds. It's only for people with exceptional cases, and the applications are assessed on a case-by-case basis. That's the stuff in black and white on the website. But Anna, you've been up the last few nights until 1 a.m. preparing 20-page submissions and such. Talk to me about what humanitarian and compassionate grounds really are to real people.
Certainly. So the reason why some of these applications, the cover letter itself is 20 pages in the one that I was just working on, is because there is so much that you can say about an individual's circumstances, and it can really range from one case to another. I have one right now that just contacted me saying that he just wants to go into fashion, and his family back in Ghana never let him, and then his parents passed away, and he was stuck in Canada on his student work permit, studying something he didn't want to study, and now he's been on his own, living here illegally, of course, but he's been pursuing his dreams. That case is so very different from another case where, for example, someone's come from Ukraine. They came fleeing missiles and war, and they found out that they don't qualify for refugee protection. But they do qualify for humanitarian compassionate grounds considerations because of the criteria that is in this application. But what we're talking about are entirely different stories.
Yeah, it's interesting you mentioned that because I went to Google and I put in humanitarian and compassionate grounds, and this is what I got back. Headlines here from the CBC, except for the one in the bottom right, which is from the Toronto Star. We've got man who sought asylum desperate to stay in Manitoba despite deportation date. You've got a Calgary father desperate to get his wife and daughter out of Afghanistan. A family for 5 years fears being deported to Egypt will tear them apart. And inside each of these stories, the words humanitarian and compassionate grounds come up. These are the factors here on the screen now. If you're watching on the YouTube channel, if you're listening on the podcast, flick on over to YouTube. The factors considered for humanitarian and compassionate grounds go through some of these where someone would have a successful HNC application and would be entitled to stay in Canada as a permanent resident.
So yes, we're looking at, it's 3 main categories, and then we also add the best interests of any children. So how settled, that's your establishment. So since you've come to Canada, what have you been doing? And in all of these cases, they're comparing your establishment in Canada versus back home. So you may have, gotten a job, you might have a whole new life here, but they will look at what were you doing back in your home country. Maybe you had a full career there. And so they're going to make an assessment about whether your establishment is really that significant here versus back home. Your family ties, you might have family here, but do you have your main family back home? Certainly in cases where most of your family is in Canada and you don't have many ties back home anymore, then you'd have a very strong humanitarian compassionate grounds case in terms of family ties. And then hardship, of course, of what would happen to you if you had to return, and also to other people. You might be assisting somebody in Canada and who's dependent on you, and then your removal, or if you had to voluntarily leave, if your application was refused, it would really impact them. The best interests of the children could be children in Canada. It could also be children back home. For example, if you're in Canada, you have children who are back home, you would want to put them on as dependents and sponsor them later on. But more often, it's about children who are in Canada who maybe you are taking care of, and your removal would make a difference if you had to leave.
Right, and those are all on a case-by-case basis, so they're going to look at those many different factors. But some people watching this might be like, hey, that sounds a lot like refugee claiming, because it's about the hardship back home or something that you're avoiding. The IRCC website itself, the government itself says, we will, quote, We will not assess risk factors such as persecution, risk to life, cruel and unusual treatment or punishment, end quote, when it comes to H&C. But Anna, you tell a different story about that.
Yes, in terms of the fact that it has to come into play in some way. If you are facing treatment that is maybe it's not as bad as persecution, maybe it hasn't reached that level, but it certainly is mistreatment, perhaps discrimination, then that would come into play. But what they're trying to say there is that it's not an alternative to, well, it's not a refugee assessment. So if you have a valid refugee claim, you should be going the refugee route. If your case is strong enough to be accepted, then there's no reason why you should be applying for H&C. You should be going through the refugee stream and going through the Immigration Refugee Board. Where you fall short, and this is why many people who start in the refugee process, and then if their claims are denied, then they go the H&C route. They are explaining that, okay, my situation fell short of the convention refugee definition, but what I'm facing back home is not something that I can live through. And that's what, for example, a lot of the people coming from Ukraine will end up applying for. If they don't qualify for sponsorship or other immigration streams, then they, because fleeing war doesn't fall under the convention refugee definition, they would be explaining, no, but I am facing extreme hardship.
I wanted to make sure we did note, and you pointed out to me, so I got it on there, that you cannot apply for humanitarian and compassionate grounds if you have a pending refugee claim. Is that right?
That is correct. And not only that, but there's a 1-year bar after your refusal on your refugee claim. You have to wait for a year before you can apply for H&C, unless there is a child who would be impacted, a minor, by your removal, or if you have some medical issues that you would require treatment that is not available in your home country, then you have an exemption to the 1-year bar.
Okay. Removal orders. So this is what it comes down to. Those headlines that we showed, basically all of them dealt with people who are facing removal and wish to stay in Canada through the H&C route, or they have been removed from Canada and they're hoping that the H&C route can bring them back. What say you to the question of, if you are removed from Canada, can your H&C claim still be processed?
It can. However, once you've been removed from Canada, the likelihood of it being accepted is extremely low. I had heard a statistic years ago, but I don't imagine it's changed much. It was 3%. And the reason for this, though, is not necessarily that the person didn't have grounds to request H&C consideration. But the problem is, once they're removed, they have shown that they have gone back to their home country. They are living there. And the officer would expect that if they've gone back to their home country and things are not okay, then they should be able to provide some additional evidence of this to show that what they were saying, what it happened. They said that if they went back, that they would be struggling, and look, here's the evidence, I'm struggling. Without that, it's the officers only able to see that they are now living where they used to live. And it's much stronger when you haven't left Canada yet and you're saying, look, if I go back, this is what will happen to me. So that's one reason why it's perhaps such a lower acceptance rate. Once you're under removal, I would add that H&C is not something that will stop removal on its own. It doesn't automatically prevent removal. It's an application that takes a long time. It used to take 3 years. It's gotten better, 1-2 years. But during that time, you can be removed from CBSA. And the only way to stop that is through a different application that's not H&C. It's a deferral of removal or a stay motion. So that has to be done in conjunction with the H&C. It's not just the H&C that's going to keep you in Canada. So the people who are in these news reports who are hoping to stay on H&C grounds, hopefully they are able to use those other routes to stop the removal, so that they can get a decision on their case before they are removed.
I mean, I think it's pretty obvious that someone who wants to go the H&C route is going to need representation of some kind, like yourself. What do you want to see from people when they contact you initially?
So we do need to know that there is a case to work with, because I personally do not work on H&C applications when I know that there isn't a chance, when the person doesn't have at least one of those three categories, a strong amount of supporting documents. They have to understand that just being in Canada for, sometimes people have been here for decades, but they came and they've been here legally, and they have the idea that because they've been here for so much time, then that gives them grounds to request to stay permanently. And that's not the case. And if it was, then a lot of people would do it. And Canada doesn't want to, award that behavior of coming and breaching immigration rules and then saying, well, now that I've been here this long, can I stay? So they really are discouraging that. And that's why they're saying that this is an exceptional kind of granting of permanent residence. It cannot just be that, I'm here and I'm working and I'm in a relationship and I really love Canada. People have to be prepared to provide a lot of documents, a lot of evidence about what they've been doing in Canada, how they are involved in their community, how them leaving Canada would leave a void. And this doesn't have to be like that you're a saint and you're volunteering everywhere. Some people have just been, they might be self-employed and have a business where they're providing jobs for Canadians. And that they might be just doing that all day and every day because they're a very hard worker. And so the cases are all very different. So it doesn't have to be that you're a member of your church. You just have to show that you are someone who is doing things and that you have made your time in Canada really count.
And the person who can help do that is Anna Aazam. Anna, thanks for contacting us. Anybody who needs help or wants to learn more can contact her at the address they see on the screen. Anna, we'll talk to you again soon.
Thank you, Sean.
Bye-bye.